What's up, everyone? Welcome back to the channel. Let's talk about it. And in this video, I want to talk about a very crucial event that happened along the way in my appeal journey in the Kitchener Divisional Court. So what happened was ultimately one of the judge's endorsements, it was originally an 8-page endorsement that had crucial information on, it had gone missing. And when a request for that endorsement was made and received, that new endorsement was significantly short and ultimately was deleted and altered. This event, I believe, tainted my whole appeal, and yet no one seems to want to talk about this missing endorsement, this altered and deleted endorsement. So just I want to thank everyone for taking the time to watch this video and to listen to my experience about this event. I gain nothing from misleading or bashing anyone. I'd rather be honest and truthful because a lot of very questionable, shady type of conduct I've experienced, and it's being swept under a rug. So I filed for an appeal for a landlord-tenant decision in June of 2023. I've said in a previous video about my experience with the Divisional Court, there were so many issues that happened, including the applicant's lawyer, who initially evicted me through an email, directed his client to evict me in the peak of COVID in the winter. Tens of thousands of dollars. My property got damaged. 3 animals died. It was horrible what happened. You guys can see all the information in previous videos, the landlord tenant and the divisional court videos I did. So I filed this appeal in the divisional court, originally in Toronto. They moved it to Kitchener, and that's there was one day before Justice Elizabeth C. Shiard. She decided to transfer it in Kitchener because John David Ekpenyong straight up lied and told this judge that the appeal happened in Kitchener, when it never did. It never did. The landlord-tenant tribunal, 3 hearings that happened, all took place in Toronto. And to my knowledge is that anyone filing an appeal, you file it within your jurisdiction. And that's what I did. I will be making a video about the many, many lies that John David Ekpenyong has said on record. And I just think it's in the public's best interest to know what I experienced with this lawyer and how the Law Society is failing a lot of people, including me, with a complaint of John David Ekpenyong. So I filed the appeal. John David Ekpenyong did not meet any of the deadlines. The appeal was straight up prejudice throughout the 20 months or so that it endured, and they were all delays because John David Ekpenyong would not file his materials, and ultimately the courts just allowed all these late filings. Judges allowed it. The appeal judge, the judge sitting in for the appeal, Justice John Konchenko, he said in his endorsement, which I'll get to, is that it wasn't prejudice filing the late materials, but it was. That was absolutely prejudice. It was a handicap match every time going up in this court, most of the time anyways, when it had to be a decision made. There's a serious pattern of this against me. And not to get off topic too much, but just to get back to this appeal, is that the event that I'm talking about is on May 24th, 2024. We're before Justice Kitchener Braid. And at this, it was a motion to introduce fresh evidence, new evidence, and it was John David Ekpenyong was, he wanted me to put up money because he thought I was going to lose the appeal, which I ultimately did, which was absolutely ridiculous. It's the amount of work I put into that divisional court application was torturous. and it was for nothing. And it was evident I was a tenant who was illegally evicted. And then so we get before Justice Braid, and she wrote an 8-page endorsement that eventually got deleted and altered. And I'm very concerned about this action, because when I look up when someone deletes and alters a document, the definition forgery comes up. So I'm trying to figure out, is there an element of forgery that tainted my case? Or are judges allowed to go behind parties' back, delete and alter an endorsement without notifying anyone? Because that alone there seemed very shady, to be blunt. And, you want to change an endorsement. How about at least notifying parties? But when you don't notify it and you delete 8 pages of a endorsement, it is very suspicious and concerning, and I think should be seen as a misconduct. And I'm going to get into sharing this information with the Canadian Judicial Council and what a broken and corrupted pattern these screening officers are showing. So I'm going to get into that as well, but I think it's important. So I can make this. So the endorsement that got deleted, I knew it was deleted when I seen the new, the shorter version of the endorsement. So the Kitchener Court civil staff couldn't find this endorsement, so I knew to order transcripts. I ordered transcripts from a transcriptionist, and basically, anytime you order transcripts, a judge is supposed to review them to fix any potential grammar issues, not to change anything, not to alter anything, and it should be done relatively in a short period of time, depending on their schedule. 1 week, 2 weeks, you would think tops, maybe a few days, right? If you're just looking for grammar issues, you're just going to skim through it, right? Well, Justice Braid took 8 weeks to render those transcripts. And ultimately what happened, if you look at them, the double spaces were taken away, the numbers on the side were taken away, and possibly the font shrank one size. Like, these were transcripts that were crunched together, and almost hard to read, because generally there's a double spacing. There's numbers on the left side column when you want to reference something. That was all missing. So I get the original endorsement back, and I'm reading through it, and it's a little bit confusing, to be honest. And I would really like someone to review these 2 endorsements, and maybe they can help me. But part of the endorsement, it's like, so I went to introduce police reports that were hidden, that the applicant and her lawyer, I believe, maliciously and intentionally withheld, because one of the 4 police reports where nothing, they try to. You could deal with family. You deal with certain people. They either have this insight when it comes from a malicious place, or they're coached. You build up this history of these police reports, and then it looks like the other person they're going after is bad. And it's like this. So this is what they tried to do. But one of those police reports that John David Ekpenyong's client spoke to the Waterloo Regional Police about was, they admitted when I got illegally evicted, they admitted I was paying rent. I was paying $750 a month for rent. I was a tenant, and they applied to the Landlord-Tenant Board for an eviction application. Well, Justice Braid's endorsement here, it's a little confusing, because what happened was I introduced, I thought it was 3 police reports, but it was actually 4. And that I didn't have access to, because I didn't write them. And even if I did order the police report, it would all be blocked out for freedom of information, privacy, right? So in the original endorsement, the one that got deleted and altered, it's a little bit confusing, because part of it says that the judge will, it seems like she'll allow those police reports, but she'll not allow any further police reports. So that's where it's a little bit confusing. But what I want to read on this original endorsement that Justice Braid wrote and I think it's important as part of the endorsement, she says, the test for admitting fresh evidence on appeal is straightforward. The court should consider the following criteria when determining whether fresh evidence should be admitted on an appeal. 1. The evidence should generally not be admitted if, by due diligence, it could have been adduced at trial. Right? Provided that in this general principle will not be applied as quickly in criminal case as in a civil case, the evidence must be relevant in the sense that it bears upon decisive or potentially decisive issue in the trial. The evidence must be credible in the sense that if it is capable of belief, for the evidence, when evidence must be such that, if believed, it could reasonably, when taken with other evidence adduced at trial, be expected to have affected the result. And she says the case. Evidence will generally not be admitted in civil appeals if due diligence it could not have been adduced at the hearing. In civil proceedings, so she goes on about this. She goes on. So part of it, it's saying like she won't accept it. Part of it, she will. Right? Why wouldn't a judge, if anything, why wouldn't they accept a police report that was hidden for 2 years? So this police report wasn't available until when I got dragged into and thrown into the family court trial, where the judge sitting in, Justice Gibson, would have seen these police reports on Caseline. So these police reports were withheld for 1 year dealing with the landlord-tenant board. Same with the eviction application. It was withheld. So the conclusion here, so we'll go down. Conclusion, fresh evidence application. In this case, I find that fresh evidence should not be admitted if the applicant had acted within due diligence. He could have abducted this evidence at the hearing. Since in the civil proceeding I apply restrictive approach, these should be finality to the proceedings. So why would this judge not allow me to produce it? See, this is so contradictory to the events that actually happened. I don't have access to these police reports. I only got access to them because the applicant and the homeowner, they withheld them. So that was kind of crap, that comments would be made, right? Wouldn't it make sense if a police report where the applicant withheld and her lawyer maliciously and wrongfully, withheld because they knew, they admitted that it was a tenant, that it was paying rent, they applied to the landlord-tenant board? That is a crucial document. That it was night and day, the living situation. But the main issue is that this, so that's one thing there, right? Why wouldn't a judge introduce that? Allow someone to introduce that if it wasn't available? No, it wasn't available, and it's ridiculous. I'm sorry when I read that, and it's just, all this stuff could have been avoided. A lot of it could have been avoided. But the problem is that this 8 or 10 page endorsement went missing. And that's the issue here. That's just the real issue, the way it was done. So that was prejudice. And then not only that, John David Ekpenyong was ordered by Justice Standrick to submit all of his materials by March 1st, 2024, which he hasn't done. Right? This is, I'll tell you right now, this lawyer has done this in the family court, and when I went to the Court of Appeal for the family court, the appeal, the divisional court, small claims, he got noted in default. He's trying to make me a fictitious litigant. I'll tell you right now, those 5 cases were there. He doesn't file his materials, and he doesn't even confirm his attendances. And this is another issue with this lawyer. There's been adjournments because he doesn't confirm his attendance, which is sometimes very suspicious the way it's laid out. But he doesn't do that. Other hearings are still commenced, and he doesn't confirm his attendance. So I don't know. It's a lot of mixed handling in this court. But And then the other thing was when I went to that appeal, when we finally got to the appeal, March 5th, 2025, John David Ekpenyong submitted his materials to me on New Year's Eve at 8:01 at night while I'm out with friends and family. And he was directed over a month previous to upload them before the 31st, 4 p.m. And John David Ekpenyong ignorantly sends them to me on New Year's Eve trying to get me upset. This is this lawyer's tactics. And the problem is when he behaves like this and conducts himself like this and the courts allow things to move forward and they don't question him, he thinks this is okay to conduct himself like that, and it's not. They're encouraging him. It just doesn't make sense. So I'm trying to figure out what happened with this endorsement. No one's mentioning it to me. Sorry, another thing I want to bring up is that I did file a complaint in the Canadian Judicial Council about this action. Justice Braid's 8-page endorsement getting deleted. But we don't know by who. No one seems to answer to it. It was done very suspiciously behind our backs. Nobody was notified. Some are saying it's forgery. I don't know. When I reached out to the only body in Canada that handles complaints against judges' conduct and that are potentially a misconduct, and you have these screening officers, like, the one that answered it was OL. There was Robin McKay, who's dismissed a complaint before, and it was absolutely ridiculous, this person's contradictive response, and now you get screening officer OL. So I reached out to the Canadian Judicial Council. They ignored me for almost 2 months. They could have had the decency to say, "Hey, we got your application. We're gonna review it." Nothing. They left me hanging. Didn't even acknowledge it. I sent a couple emails like, "What's going on?" They still ignored me. Again, these are like public servants that are funded by the Department of Justice. They're funded by the Ministry of Justice. So they're funded by taxpayers. They kind of, my experiences, they conduct themselves like some of them, these screening officers, like they're very comfortable. It's like a corporation. But this OL screening officer responds back to me and tells me that my complaint is abusive and fictitious. I was totally shocked when I read that, because here I am saying, look, this judge altered, this endorsement was deleted and altered by this judge. This is not, like, what's up with that? Like, this tainted my case. There was other information on that endorsement that I intended on to rely on. Aside from the court being extremely prejudiced and allowing Mr. Ekpenyong to file his materials 1 year late. Think about that. This guy had 30 days to file his materials. Not even 30 days. He had 2 weeks. He took 1 year. And Justice John Kronchenko said in his endorsement that would not be prejudice because I got my materials well in advance. No, it was prejudice. Because if that was me or anyone else, they probably would have denied it. Just like Justice Braid denied to introduce fresh evidence. Police reports that had critical information that would have knocked my appeal out of the park. And this judge interfered and blocked crucial documents that were not available at the landlord-tenant board, but later on at my family court trial. And then the judge at the appeal is going to say that it's not prejudice to give him a year to file his materials. So it's like, it's this handicap match every time dealing with this court. It makes me so upset, makes me so frustrated when I think about it and I talk about these things. And, it's, to be honest, I don't want to be doing these videos. I don't want to be sharing my experience, the honest truth, being so calm and collective about it, because that's the only way to do these things. But I thought it was absolutely ridiculous from the Canadian Judicial Council telling me, commenting that. So that's just kind of what I wanted to share, that there's this event along the way of the appeal. There was this important court document that got missing, and ultimately it got deleted and altered by, I believe it was Justice Braid. No one has answered to it. I reached out to the Canadian Judicial Council, and they're basically telling me I'm abusing the complaints service, telling them that a judge had deleted and altered a document that they shouldn't have, and nobody was notified. So I've got the 2 endorsements, the new one and it was just something that happened in this whole appeal thing that really tainted my appeal. And again, if anyone's thinking about, if you can avoid the divisional court, if you can avoid the heartache, the stress, the financial burden, you see the work that I did, and if you were to hire a lawyer, it would have been like 60 grand, for sure, 60 grand. I'd like to share my materials one day. Oh my gosh, I was so confident, thinking it was a no-brainer. I was a tenant. I was renting the basement of an ex-girlfriend, and you guys can see in the other videos just everything that I went through, the facts, the very questionable conduct from these individuals in charge for managing these appeals and cases, and I just wanted to share that about the endorsement getting deleted and altered, and everything in between. So thank you guys for watching, and if you like these type of videos where I'm sharing the honest and brutal truth about my experience, dealing with these court proceedings, which I don't want to be involved in at all. I can't get out of it. I feel like I'm stuck in a web of psychotic behavior from individuals that are, I don't know why they're doing what they're doing. I was a hard-working electrician. I pretty much lost everything. John David Ekpenyong and his client are straight up getting away with abusing the court process. They are getting awarded cost for work that was never done or money exchanged hands, and the courts they continue to deny my request to get proof of payment of these bills being submitted, because it's money that was never spent, and I have to pay money that, they're profiting at this point. They have the impression they can get away with abusing the courts process and profit and not go after court cost. So I'm just going to leave it at that. And this video was about this endorsement that got deleted. And I'd just like some answers. If this is okay, if this is normal practice, if judges do this, then hey, then I guess it's normal to a judge to delete their 8-10 page endorsement, not notify anybody, and put a different endorsement. And I knew that, and I got proof that this was done with the transcripts I ordered. So that's my experience with one of the critical events in the divisional court. And I hope my videos are helpful, and just thank you everyone for watching.